Good evening, I am Amadin Ogbewe. Now tonight we'll be taking a look at the decision of the Action Alliance to withdraw its case against INEC for excluding its candidates during the general elections. I've been joined now by the counsel to the party, Mr. Oba Maduabuchi, Senior Advocate of Nigeria. He joins me now to share his thoughts on how the suit went and also on the hope for the election tribunal as it continues past today. Right, Mr. Maduabuchi, it's good to have you on the program.
Thank you very much. It's a pleasure.
Let's start from the basics, or let's start from what happened yesterday and then get a better understanding. What really happened in court yesterday with the Action Alliance and their suit? The news says the AA withdrew their suit, but we also hear that there was apparently two lawyers in the courtroom who were, or another lawyer, so to speak, claiming to be representing the AA. So can you really tell us what happened yesterday?
Well, after the elections, particularly the presidential election, INEC fielded a candidate, the name of a candidate that was not the candidate submitted by the party Action Alliance. For some time, there has been some form of tussle, leadership tussle in the party. I know because I did most of the cases. And one man called Kenneth Udeze, was claiming to be the national chairman of Action Alliance. The team went to court, to the Court of Appeal, on 9th January 2022. And the Court of Appeal told him, my friend, you are not a member of Action Alliance. How can you be talking of being chairman? In November last year, the same issue came up in the same Court of Appeal in Abuja. And the Court of Appeal said, we've told you since January that you are not a member of Action Alliance. All these judgments I packaged as counsel to them and wrote a letter forwarding the judgments to INEC. I said, please, this is the situation. This is the person recognized by law as the national chairman and head of the National Executive Committee of Action Alliance. Please deal with him. INEC refused to acknowledge even the letter. I was baffled. I went before Justice Zainab Abubakar of the Federal High Court, Abuja. I said, please ask under INEC to upload this list as the authentic list of the Action Alliance. She made the order. My Lord Zainab Abubakar made the order. I got a copy of the order and forwarded again to INEC. INEC refused to obey the order. Justice Nyako, I went before Nyako again. I said, we have finished with presidential. This is gubernatorial and the House of Assembly. Order INEC to recognize this list as the authentic list of candidates for Action Alliance in this general election. She said, oh, but why are you bothering yourself? You already have an order directing INEC to deal with Omoaje as the actual national chairman of Action Alliance. Why are you bothering yourself? That order is enough. I packaged it again and sent to INEC. INEC ignored the order. And I wrote a letter to the INEC chairman. I wrote to the National Security Advisor. I wrote to Senate President. I wrote to Speaker of the House. I wrote to the Secretary of the Government. I said, look, this thing can truncate our democracy. Democracy is rule of law. when positive orders of court are so brazenly disobeyed by an agency of government, then where are we going? So the elections were held. The candidates of Action Alliance were excluded. So I went to the tribunal. I said, you have excluded my clients, the proper candidates nominated by Action Alliance. Why should you? And I warned you. So I filed a petition. And it is basically against INEC. INEC, in their response, said that they thought the issue had been settled. So if I knew this, I would have brought their response. That they thought the issue had been settled, that Oba Maduabuchi is now national chairman, while the candidates brought by Kenneth Udeze will be the candidate for the election. I laughed. I said, the nomination of candidates is a legal process. It is not something you do the way you want. When the law says you must do something in a particular way, you don't have any option but to do it in that particular way. If Section 84 says you must hold primaries, and whoever wins the primaries is the candidate. If, as it is, Action Alliance has held primaries, and Solomon David Okubwan emerged the candidate, if you bring Al-Mustafa, Hamza Al-Mustafa, all of us know him, very sharp person, personable. You see him, you must like him. But for purposes of the presidential election, he was not the candidate of Action Alliance. If INEC decides that he is the person they want to field, then of course we have a ground to question the election, and that was what we did. Now, yesterday, politicians know how they meet, when they meet. I'm not a politician, I'm just a lawyer. So last week, I think by Tuesday, they called me and said, we have held meetings and we've decided to withdraw the petition. It is not for me to ask a client why he wants to withdraw. It's not my business. So I said, is that your instruction? Give it to me in writing so that tomorrow you do not say you didn't know. So they wrote to me and said, withdraw the petition. I instructed my staff. They wrote an application, which is the normal thing. And we filed it. And that was what we moved yesterday, and the court dismissed the petition.
What about mentions of another
yes,
lawyer?
I'll get to that.
All right, sir.
Now, when the petition was called, because petition number 1,
yes,
and I announced appearance for that problem of Kenneth Udeze and Oba Maduabuchi reared its head again. In spite of the multitude of court orders, which I said, my friend, you are not even a member of Action Alliance. We're not talking of being national chairman. You are not a member. You've been sacked, suspended, then later sacked. The judgments are there. So how can you come and be talking of... So I was a bit embarrassed when somebody sitting behind me, there were so many lawyers that those of us who claim to own the front seat, some of us had received about 4 seats behind because there were too many senior advocates yesterday. So I was embarrassed when somebody said he's appearing for Action Alliance. And the judge, the presiding justice said, somebody has already announced. So how can you people be bringing this kind of thing? But I got up and said, my Lord, all these things, they are not necessary. We don't need to go into all that. Because if you go into all that, what we'll be bringing here is a pre-election internal leadership problem of Action Alliance, which has been settled judicially by the courts. I have instruction to withdraw this petition. They said, if you have instruction to withdraw the petition, then why is anybody fighting? So they asked me to move the motion. I moved the motion, and the thing was dismissed. It is now left for the party to take it up with INEC that has sworn on oath in their defense to that petition that what was agreed was that Omoaje is the actual national chairman of Action Alliance. How they now got up again yesterday to say that they are the people Action Alliance must, or INEC must deal with, becomes baffling. But like I said, that is something that we'll take care of in the next 1 or 2 weeks.
All right, just to clarify, INEC's defense, when did that come? Was that yesterday? Or?
No, when you file a petition, all the defendants, or respondents rather, file their own responses. So INEC was served with our petition. And INEC, in its defense, and on oath, said, I thought we had sorted this issue out, that Omoaje is the national chairman of Action Alliance. It's on oath. I have a copy. If I knew this would come up, I would have brought a copy to read.
That's fair enough. I just want to get your professional thoughts now.
You will pay.
I don't think I can afford this. But with that being said, what are the implications? I know the case is the suit has been withdrawn now.
Yes.
But what was the implication? Should that case have gone through, that the candidate who was not meant to be on the ballot, on the ballot, was there? Does it affect the whole election?
Of course. It affects the presidential election. That is what we call unlawful exclusion. If you are basing your petition on exclusion, you need to do 2 things: validity of nomination and then unlawfulness of exclusion. Of course, validity of nomination gives you an entitlement to contest the election, right? Once you are validly nominated. Then once you are not allowed to contest that election, the exclusion then becomes unlawful. You understand? And once you are excluded, whether you will win it or whether you will not win it, but you've not been allowed to participate, the election will be cancelled.
All right. Interestingly, I believe there were other parties who had similar, or to an extent, a situation where even though court judgments ruled in favor of certain candidates or factions, the reverse ended up happening. But that being the case, I'd really like to understand what level of response you got throughout all of these cases. You said the letters were not responded to.
INEC was determined to exclude Action Alliance. That's why if you saw me on television yesterday, I was angry. Because we needed to tell INEC that it only is meant to organize elections, not defy court orders. What I have of my life I spent as a lawyer. I don't think I will live, the number of years I've been a lawyer, I can't leave it on earth again. And I can't be watching an organization, the taxpayers pay, bringing the legal profession and the judiciary to shame. That is why APC lost Zamfara. Because they disobeyed court order. APC was the party in power, yet they lost Zamfara. All the seats, they won everything, but all of them were swept away and given to PDP. That was why APC in 2019 or 2015 could not contest elections in Rivers State. Because there was an order that you shouldn't hold Congress. They went and held Congress. In the first place, take notice that a court does not have the power to stop a Congress, because it is an election, it's an electoral process. The electoral law says you cannot stop an election. An election is not what happened on 25th of February. An election starts from the day INEC says elections are scheduled like this. You are to hold primaries, you are to hold this. That is the electoral process. So you can't stop any of them. But a judge made order stopping congresses The APC flouted it and held congresses, and the Supreme Court said you can't even contest elections. And they did not contest. If the Supreme Court has done that, I don't need to tell you what would have happened if this petition had continued. And we bring the barrage of judgments and correspondence. Do you know that Kenneth Udeze was given a cost of 1 million naira by Federal High Court because he presented himself as national chairman in one of the suits? In fact, on 2 occasions, 1 million. And that is the person INEC is dealing with. My friend, you are not a member of Action Alliance. That is the person INEC elected to deal with. So, the result of the petition, in my humble opinion, is a concluded thing. You would have, but how do you spend over 400 billion? And because of the sensitivity of one man, we allow it to go down the drain. And you start and spend another 400 billion conducting the same election because one man. But that is INEC for you. That is INEC for you. Upload results, they won't. They do the things the way they want. So that's the problem.
Yes, sir. So what's the way forward in 2 aspects now for the party? And then secondly, so that we get more, like call it sanctity or for court orders. We were seeing a lot of flouting in different cases. How do you think we can get to a time where it's a different ball game? Specifically in this situation, what would have been the ideal resolution so that, whenever court orders are given by the court, it's not a matter of we will decide if we want to follow it or not. It's you have to, and you know what comes if you don't. How do we get to them?
INEC must realize that even during the military interregnum, one part of government that was not touched was the judiciary. Everybody realizes the importance of the judiciary. One position the military never touched was Attorney General of the Federation. That section of the Constitution was never suspended once. It was never. So that tells you the importance. The only ministerial position created by the Constitution is the Attorney General. You cannot say the Attorney General told me. The Attorney General cannot say do this. Even the President will not say no, ordinarily. INEC should listen to their legal department. Now they have about 5 or 6 senior advocates, led by Tenimu, my friend. They should listen to them. Legal issues are not subject to political solutions. In law, we don't play politics. Law does not speculate. A politician speculates. Law does not look at your face. Law does not consider anything except what the law is and what the law says. So INEC should insulate politics from law and the judiciary. They should listen to their legal department. When the bubble was about to burst, the legal department did something I commend. I'm still commending them. They set up an ADR, dispute resolution. Invited Kenneth and invited, because now they saw that these 2 men are obstinate. And INEC was going to bear the brunt. If you do the election and use Kenneth's candidates, and we go to tribunal as we did, the chances are that the election will be cancelled. But they had already uploaded the candidates of Kenneth in defiance of various court orders. So that was the quagmire. That is why they now hurriedly set up an ADR. And we are pleading with Omaje, please, we've made a mistake. accept, we will now recognize you as national chairman and deal with you henceforth. So, but if INEC, management of INEC had listened to the legal department from beginning, they wouldn't be in that position. They wouldn't need to waste money engaging an arbitrator to come and arbitrate the matter. It would have been necessary. They must learn to obey court orders. But look at what they did with APGA. Supreme Court says Dozie Njoku is the national chairman of APGA. Do you know what INEC did? Supreme Court. INEC said they want to set up a committee. I mean, the thing makes, it keeps ringing a bell in my head. Set up a committee. To do what? Committee of what? Committee of who? If a lawyer sits on that committee, I will report them to the Bar Association. If any lawyer sits down and says, we want to see whether we will obey the Supreme Court or not, based on what INEC, I don't know what to call it, management tells them, we will not take it lying down. Because we don't have any other business. We don't have any other market. We don't have any other shop. How can Supreme Court tell you Dozie Njoku is national chairman of APGA? The Supreme Court that can tell Tinubu you are no longer elected. That can say they don't want this studio here. That can say Oba Maduabuchi, you are no longer an SAN. In fact, you are no longer an Igbo man. That can say nobody should wear trousers in Nigeria again. That's the awesomeness of their power. They have said, this is the man you are to deal with. And I'm on television, so I have to be careful with my words. Say they want to set up a committee. If they could do that to the Supreme Court, what have they been doing to the Federal High Court? You can just imagine the disdain they have for Federal High Court. So that is they should learn. The way forward is that they must learn to recognize that pronouncement of a court is, you don't have any option. You just have to accept it. What you do is you go on appeal. When INEC recognizes that, things will begin to change. But insofar as they persist in their obstinacy, they were lucky this time. They are very, very lucky. Yesterday, I couldn't understand why I was withdrawing such a petition. I just couldn't understand it. Because we would have liked to hear what they will say in defense. This is judgment of the Supreme Court, which says this man is not of the Court of Appeal. This man is not a member of a political party. And you collect a list of candidates from him. And 2 days to the election, on 23rd, you say come for ADR. 23rd, the election holding on 25th. So I was livid. I didn't like it. We needed to show them, even if for nothing, don't try this next time. But politicians are politicians. They have their political considerations are different from what we as lawyers consider. So the way forward is for INEC to listen to the legal department. That's very vibrant, full of extremely good lawyers. The lawyers that work in INEC, each of them goes to the Supreme Court over 20 times in a year. Well, there's no political matter that does not end up in the Supreme Court. And there must be INEC lawyers. So they are versed in these things and they know it. But those people who are up there should listen to those boys.
All right, sir. One more thing that I would like to clarify. Yeah. When we see issues like this, for instance, I'm speaking to you now, the counsel to
Action Alliance. Yes.
Action Alliance, pardon me. Now, when I speak to perhaps Kenneth Udeze or his representative, sometimes what we often see is that they come with their own courts judgments or documents. To use an example now, currently there's something going on in the Labour Party. Now, the Julius Abure-led Labour Party, they say the courts in Edo State in Benin said this. The other one says the courts in FCT Abuja here said this. What happens, for us, as those who are not in the profession? How are we supposed to gauge these things and to know, this is where it should be or this is the right thing?
Now, you see, in the first place, that thing is a horrible abuse of judicial process. Whether a court is right or wrong, once it makes a pronouncement, it's sacrosanct. You wait. I don't like I can't imagine a ward chairman saying he's suspending the national chairman of a party. As the councillor saying he's suspending Bola Tinubu, removing him, or an area court judge saying removing Bola Tinubu. But if it is pronounced, whether it is right or not wrong, we must obey. Right? So, that situation is not for you. That situation is for the NJC. Because, like, when Mukhtar was CJN, no judge will try it. When Belgore was CJN, no judge will try it. That the judgment in the court of coordinate jurisdiction has made an order, then you go and make a counter order. How dare you? How dare you? That is why in the Federal High Court, where these things more often happen, they have been told, once there is a judgment of this nature, send it to the CJ of the Federal High Court. Once there is any suit pertaining leadership of a political party, send it to Abuja. It is the CJ that will assign it. So that if there is an order, another court does not give either a conflicting or similar order, one judge will handle it. Right or wrong, I have said, I do not. That was how Uche Secondus was removed. A vacation judge in Borno, in Bonny, removing a national chairman resident in Abuja. Vacation judge that does not have power even to try landlord and tenant. Removed the national chairman of a political party. And the NJC is there watching. So it is not you, it is the judges that should know. And then us as lawyers, when such an order is made and they bring your client seeking for an alternative or conflicting order, you should be man enough to say, no, keep your money, I don't need your money. And if you are the counsel to the other side, you go and tell them, please, there is an order subsisting somewhere. Because we will have to give it to them. They may not hear every time that something has happened. But the moment you get to know about it, you set aside your own order. Because there's a previous order made. Yeah. Then NJC, like during that circus, River State gave one order, Cross River gave one, Zamfara gave one, Jigawa gave one, and all the justices are still sitting. If the NJC had moved, then what is happening in Abure now wouldn't happen. If NJC had called all of them and said, pack your things and go, because you're embarrassing us. What is happening now wouldn't happen. So it all goes back to, what did they do? They said, don't do it again.
All right, sir. We're almost out of time, but I just want to slip in one final question. It's not every day we get to speak with a senior advocate of Nigeria. I'd like to get your thoughts on how you feel or how you think the process, talking about the tribunal, yes. The Action Alliance might have withdrawn, but we know their case is still ongoing. And there have been advice, recommendations here and there, how the process can be swifter or made in a better manner, or so to speak. I'd just like to get your recommendations, your advice or your thoughts as to how the process should continue so that Nigerians can have that peace of mind that justice has been done.
You see, the first thing is that the person that did an act ordinarily should be the one to say, I did it well, this is how I did it. INEC conducts elections. But it is me, sitting in my house, they will ask me to come and prove that how INEC conducted his election. I think it's wrong. If I say, INEC, you did not conduct this election well, And INEC says, no, I conducted it well. In law, he who is asserting the positive of an issue, the affirmative of an issue, has the onus of proving it. I cannot say you did not. You cannot prove negative. Have you ever heard where it is difficult for you to see an election petition succeed? Except in this one I just withdrew. That's the kind of election petition that will succeed because it's basically documentary. These are the judgments, these are our candidates, and they were excluded. We don't need much ground. But if it's any other thing, it is nearly impossible for you to succeed. Because you don't know the inner workings of INEC. You don't know how they did the election. So how can you prove that they did it wrongly? So the first thing to do is to change what we call the onus of proof. The onus of proof must go back to INEC to justify the result it announced. That is the first step. Otherwise, they will announce and say, go to court. They announce what they like. I remember in those days in Anambra State, INEC told the world at an election petition tribunal that we were directed to return PDP, that they will send us their list of candidates later. Can you imagine that? People voting do not know who they are voting for. And they announce PDP as winner. They will bring us their candidates later. Secondly, because of the size of Nigeria, and the fact that we do 90% of our electioneering manually, we have to start earlier to challenge, to conduct our elections. I don't see why we can't do elections in August. If you do elections in August, and by January, February, you have finished with the first level of judicial intervention. Another 30 days, 40 days, you finish with the appellate intervention. I can't imagine anybody telling a sitting president, I've removed you. We haven't developed to that level. Somebody's Tinubu, the Supreme Court said, Tinubu, we are removing you. It will be very, very difficult. But if he has not come in, if he has not been sworn in, somebody who can muster courage and say, this man, you didn't win this election. You did not win, so we have to remove you. Like, there was a time when, I can't remember exactly now, there were 4-3 in the Supreme Court. There were 4-3. If it was not an incumbent, that thing wouldn't have been 4-3, because the Electoral Act says you conduct elections with serialized ballots. And the main issue in that suit was that the ballots were not serialized. And everybody accepted that the ballots were not serialized. That is a big infraction. But the Supreme Court prepared over it, and 4-3. 3 people said, Mukhtar, Oguntade, and said, no, this is wrong. And the other 4 said, well, how does non-serialization affect the election? So let it be. I'm not saying they were influenced. You know, the Supreme Court is a court of policy. There are many times they make decisions based on policy. Let's not topple the apple cart and things like that. But I believe that if these things are done before the person who won is sworn in, they will be more prepared to say, no, don't swear this man in. But the law is that you cannot stop an electoral process. I've told you that. Which starts from primaries till swearing in. You can't stop any part of it. So we should start early. Hold the elections in August, then start petitions in September. First stage, February. Second stage, April. And the May is fine.
That's fair enough. Mr. Oba Maduabuchi, Senior Advocate of Nigeria, thank you so much for coming on.
It's my pleasure.